Hello, everyone. Welcome back to our channel, U.S. Immigration News. We hope you're doing great. Well, in today's video, we will be talking about 5 paths to legal status for undocumented immigrants. So, to get all the information, pay attention and watch the video through to the end. Please hit like and subscribe. And don't forget to push the notification bell for upcoming episodes. So, without any further delay, let's jump into the video. Navigating the complex landscape of immigration law can be daunting for undocumented immigrants seeking legal status in the United States. This video explores 5 primary avenues to achieve legal residency, offering insight into family connections, employment opportunities, and humanitarian protections. Understanding these options is crucial for making informed decisions and taking steps towards securing a future in the U.S. For undocumented immigrants in the United States, life can be difficult. The stakes are high. Getting caught means a likely removal, deportation, from the United States, but it also may break apart a family, disrupt the family's finances, and result in stiffer immigration penalties. Currently, there is no extensive amnesty program like President Reagan introduced in 1986. But there are a variety of laws and smaller programs that offer paths to legal status for certain undocumented immigrants. Although not everyone will qualify for these paths, they are worth learning about. Undocumented explained. In this video, the term undocumented immigrant is used to describe an immigrant without any legal immigration status. No status may be the result of entering the United States without inspection or entering via a valid non-immigrant visa, e.g. tourist visa, student visa, that has since expired. The term entered without inspection, or UE, is used to specifically describe someone who has come across the border and never interacted with a border agent. Although there are approximately 650,000 childhood arrivals protected by the DACA program, this is not a lawful immigration status. It is a temporary solution and provides extremely limited opportunities for beneficiaries. DACA recipients need paths to a legal status like any other undocumented immigrants. For undocumented immigrants, the clear goal is a path to a long-term lawful immigration status. These paths to legal status lead to permanent residence, green card, and citizenship. This video covers those options and who could qualify for them. Permanent residence, green card, through marriage. One of the most common questions and most common paths to legal status is the treatment of an undocumented immigrant when he or she marries a citizen or lawful permanent resident. The foreign spouse of a citizen qualifies as an immediate relative for the immediate relatives of a citizen. Obtaining a green card may be a fairly straightforward process. A lawyer may not even be necessary, however. Certain conditions must be in place, otherwise the process gets complicated, but often there are viable paths to legal status. Immediate relative with a lawful entry. The immediate relative category includes the spouse, parent, and unmarried child, under age 21, of citizens, provided the immediate relative had lawful entry to the he or she may adjust status to permanent resident. In other words, an undocumented immediate relative may generally apply for a green card from inside the United States. Lawful entry is essential. The undocumented immigrants must have entered the United States with valid documentation and made face-to-face contact with an immigration officer, and that officer acknowledged the person's entry to the. Therefore, an individual who overstays a visa and then marries a citizen may generally obtain a green card through adjustment of status. It doesn't matter if the visa overstay was only 6 months or 6 years. The undocumented immediate relative can apply for a green card. I-601A Provisional Waiver. If the immigrant's entry was not lawful or the immigrant's spouse is a permanent resident, the process gets more complicated by law. If the foreign spouse and children enter without inspection and remain in they must leave the country and conclude their immigration process through consulates abroad to obtain the immigrant visa, green card. More importantly, If the immigrating spouse and children over 18 years of age resided in the unlawfully for at least 180 days, 6 months, they could then be automatically barred from re-entry for 3 to 10 years once they leave the. In many cases, these individuals can qualify and apply for a waiver of the 3 and 10-year bars if they can demonstrate that their absence from the would cause an extreme and unusual hardship to the citizen or lawful permanent resident spouse or parent in the recent past. The waiver process required that the individual first travel out of the and apply from his or her country of origin. This was a costly and very uncertain process that still risked keeping families a part of lengthy periods of waiver approvals, or even worse, waiver denials and full exposure to the 3 or 10-year bars. Fortunately, that process is a thing of the past. A provisional waiver is now available that can be applied for and obtained while the applicant is still in the United States. The provisional waiver offers individuals some level of certainty that, once approved, they will be able to return to the United States after a successful consular interview. The Provisional Waiver Program covers the undocumented spouses and children of citizens. The goal of the Provisional Waiver Program is to maintain family unity. Extreme and unusual hardships can generally include family ties to the United States and the country of removal, conditions in the country of removal, the age of the citizen or permanent resident spouse or parent, the length of residence in the United States, relevant medical and mental health conditions, financial hardships, and educational hardships. Applicants should remember that it must be a bona fide, real marriage to a citizen and that all previous marriages must have been lawfully terminated marriage fraud. A fake marriage to get a green card carries harsh penalties that could even result in a felony conviction for a citizen. Prospective applicants should always speak to an experienced immigration attorney before applying for a provisional waiver. Form I-600 UNWEA, Application for Provisional Unlawful Presence Waiver. Although it may seem like a fairly straightforward process, these waivers are highly technical and require careful and thorough legal analysis. Your answers on the application could have long-term implications for your immigration case. Green Card through Life Act protection. Some undocumented immigrants have had the opportunity to receive higher education and become candidates for higher skilled jobs. In such a scenario, employers may be interested in sponsoring a green card for a high-skilled prospective employee. Yet, even if the undocumented job prospect is protected under DACA, he or she may still need the benefits of Section 245. I. Protection through the Legal Immigration Family Equity Act. There are many cases where undocumented immigrants, particularly well-educated dreamers, may have an employer who is willing to sponsor them for a green card. In some instances, the employer will need to go through a process known as labor certification or PERM before filing for the prospect's employment-based visa petition. However, even after such steps are completed, the process still requires the immigrant to return to their home country because of their original unlawful entry or out of status condition. Yet, if the individual has 245 I protection, they can complete the process in the United States and obtain a green card without leaving. The Life Act is a law that allows undocumented immigrants to finish their green card process in the United States if an immigrant petition was filed on their behalf, or their parents' behalf, or their parents' behalf on or before April 30, 2001. For example, if the undocumented individual's citizen paternal uncle filed an immigrant petition or I-130 petition on behalf of the individual's father by April 30, 2001, then not only the father, but the son or daughter may be covered by the Life Act's 245 provision. This is a simplified presentation of the law, and many additional requirements must be met if this scenario sounds like it may apply to your situation. Speak with an experienced immigration attorney who can explain the details. Asylum Status. Asylum status is available to anyone in the United States who has suffered persecution in his or her home country, or who has a well-founded fear of persecution. If he or she were to return to that country, it is important to understand that the persecution must be done by the government, or by a group that the government is unwilling or unable to control. In U.S. immigration law, persecution is fairly well defined. Most importantly, the persecution must be on account of one of the following 5 groups: race, religion, nationality, membership in a particular social group, or political opinion. In general, eligibility for asylum requires that you: 1. You are present in the United States by legal or illegal entry. 2. You are unable or unwilling to return to your home country due to past persecution or have a well-founded fear of future persecution if you return. 3. The reason for persecution is related to one of 5 things: race, religion, nationality, membership in a particular social group or political opinion, and 4. You are not involved with an activity that would bar you from asylum. To begin an asylum case, your lawyer must file Form I-589, application for asylum and for withholding of removal, along with evidence supporting your claim. There is typically a screening interview to make sure an applicant's case is warranted. This is why it is very important to work with a reputable organization, non-profit or legal firm, that is experienced with asylum cases. Asylees, individuals who have been granted asylum, are eligible to apply for permanent resident status, green card. 1 year after receiving the asylum grant, the asylee's spouse and children are also eligible to apply for a green card if they were admitted to the United States as asylees. Visa for victims of crime. In 2000, the Victims of Trafficking and Violence Prevention Act created the U-Visa to protect non-citizens who have been victims of certain crimes and who have aided law enforcement. The law was created to encourage victims to cooperate with police and prosecutors without the fear of deportation. A U-Visa provides legal status and employment authorization and can also provide a path to permanent resident status green card. In some circumstances, there are 4 eligibility requirements for a U-Visa. 1. The individual must have suffered substantial physical or mental abuse as a result of having been a victim of a qualifying criminal activity. 2. The individual must have information concerning that criminal activity. 3. The criminal activity violated U.S. laws. And 4. The individual must have been helpful, is being helpful, or is likely to be helpful in the investigation or prosecution of the crime. Qualifying criminal activities for a U-Visa include, but are not limited to, abduction, abusive sexual contact, blackmail, domestic violence, extortion, false imprisonment, female genital mutilation, felonious assault, hostage, incest, involuntary servitude, kidnapping, manslaughter, murder, obstruction of justice, peonage, perjury, prostitution, rape, sexual assault, sexual exploitation, slave trade, torture, trafficking, witness tampering, unlawful criminal restraint, other related crimes. The victim must have useful information related to the crime and be willing to cooperate with police and officials responsible for investigating the case. The application for a U-Visa requires a certifying statement, Form I-918 Supplement B, from law enforcement in some areas. Individuals outside of law enforcement, such as a judge or child protective services, can provide the certifying statement. Family members, spouse, and children can be covered with the same U-Visa. Family members who accompany the petitioner can, under certain circumstances, obtain a U-derivative visa. The U-Visa principal must petition on behalf of qualifying family members. If you believe your situation may warrant a U-Visa, speak to an immigration attorney an attorney can help you determine eligibility and properly contact law enforcement officials. Many nonprofit organizations work with immigrant victims of crime. You must make your wishes known early in the process. Green card through Registry. A provision in our current immigration law, known as Registry, allows certain long-term undocumented residents of the United States to register for lawful permanent resident status. Registry requirements. To qualify, applicants must have entered the country on or before a specified date, known as the registry date, and must demonstrate good moral character and continuous residence, since their entry undocumented individuals may be eligible to apply for a green card. Permanent residents, under the eligible to apply for a green card. Current registry provisions if they meet all of the following conditions. 1. Entered the United States before January 1, 1972. 2. Resided in the United States continuously since entry. 3. Are a person of good moral character. 4. Are not ineligible for naturalization, citizenship. And 5. Are not removable, deportable. Under Section 237A(4)(b) of the Immigration and Nationality Act, they are not inadmissible under Section 212A(3) of the INA or as a criminal, procurer, other immoral person, subversive, violator of the narcotic. To apply for a green card through the registry, individuals must submit form I-485, application to register permanent residence or adjust status. However, the application process is much more complicated than submitting a form. Applicants must include substantial supporting documentation to evidence entry, residency, and good moral character work with an immigration attorney for the best result. Registry movement. In the nearly 100 years of this law's existence, Congress has advanced the registry date only 4 times, most recently in 1986. The registry date was set at January 1, 1972, in other words. Only non-citizens who entered the United States by that date are eligible to apply for a green card through the current registry date is so far in the past that very few individuals are eligible. That's why the registry is back in the news as a possible way to give undocumented individuals a path to legal status. The law is well established and only needs a simple date adjustment to open the door to thousands, even millions, of new applicants to become permanent residents and eventually U.S. citizens. Last stop, non-LPR cancellation of removal. A final option for deportation defense may be available to certain undocumented individuals who have lived in the United States for a long time and have been placed into removal proceedings. You may be able to obtain lawful status and a green card through non-LPR cancellation or removal. To qualify for cancellation, you must meet all of the following requirements. 1. You have been living and continuously physically present in the U.S. for at least 10 years. 2. Your removal, deportation, from the U.S. would cause exceptional and extremely unusual hardship to your U.S. citizen or permanent resident spouse, child, or parent. 3. You can show that you have had good moral character for the past 10 years. And 4. You have not been convicted of certain crimes or violated certain laws. Unfortunately, you cannot proactively sign up for this benefit. It's only available to someone facing removal in immigration court. Meeting all the requirements above is just the minimum criteria. There's also a limit of 4,000 green cards issued annually under this law. In other words, many people satisfy all the requirements, but do not receive the cancellation of removal. It's incredibly important to get the assistance of an immigration attorney, experience with deportation defense, and establish the merits of your hardship. Even if none of the paths to legal status mentioned above apply to you, there's reason to be optimistic. Politicians, immigration advocates, and organizations are pushing hard for legislative change. that will provide relief to undocumented immigrants who are already in the United States and positively contribute to the U.S. economy. Securing legal status in the U.S. is challenging but achievable for undocumented immigrants. This video's 5 pathways offer routes with unique requirements and opportunities. Staying informed and seeking expert advice enhances success chances. With determination, the dream of legal residency can become a reality. That is all for today in this video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully, the information is useful to you. See you later in the next video. Till then, take care.
In this video, we are going to talk about the 5 paths of the legal status and the undocumented immigrants. For undocumented immigrants in the United States, is navigating in the complications of the immigration law is critical due to the high stakes of the deportations, family separations, and the financial distributions. While there are the no bond MSD program similar on the introducing the President Reza in 1986, there is a several pathway to the legal status available in the certain individual. One common route is through the marriage in the U.S. citizen to the lawful permanent residence. Foreign spouses and the U.S. citizens may be equality and equality for the green card, particularly if you have the enter in the U.S. lawful. For those with the unlawful entry in the process of the can be a complicated often, requiring the provisional waiver to the overcome 3 to 10 years re-entry barriers, providing there can be a demonstrated and the extreme hardship to the U.S. citizen, the permanent residency, spouses, and the parent. Another option is the Legal Immigration Family Equity Act, which is allow certain undocumented immigrations to complete their green card process and into the U.S. and the immigration petitions visa the field of the behalf of the 2001. This is particularly useful for the DACA response with the employer sponsorships. Asylum status is available under those who have the face reasons for the fear features and the presence in their home country based on the race, religious, nationality, memberships in the particular social group, or the political opinion. Asylum can apply with the permanent residency status 1 year after being the granted asylum. In their spouses and the children are also eligible to apply. The U visa offers the protections to the victim and the certain crime who have the cited the law reinforcement, and the visa provide the legal status and the employment authorization with their political path for the permanent residence. Lastly, the Registry Provisional allows the long-term undocumented residents who have entered the U.S. before January 1, 1972 to apply for the permanent residency, provided they have maintained the continuous residence and the good moral character also. Dispute their opinions and options, securing the legal status remain the changing, staying informed, and the seeking expert legal advice can be improved the chances of the successfully navigating the immigration process and achieving the legal residency. Hope this information is helpful for you. Thank you for the watching video. We'll get with the next episode. Thank you.